Yo, it is so easy to get your child support case terminated, and I don't care what state you're in. The only thing that you have to do is find the due process violation, and the second thing that you need to do is challenge jurisdiction. Now, if you want to know what the violations are and how you can challenge jurisdiction, I got something for you. I created a tool. You can use it absolutely free right now. Comment FCA so that you can get access to it. The next thing that I want you to do is I want you to save this post. Matter of fact, I need you to go ahead and share it with as many people as possible, because you never know who's dealing with child support. This is the only opportunity that you'll be able to get a free case analyzation from me in a new tool that I created. Comment FCA right now so that you can get yours. Why are you waiting? Go ahead and get that child support case terminated. Let's go. Here are 5 ways to ensure that you do not have to support your kids ever again. The United States Supreme Court said that paying child support does not benefit the child nor the parent. So the first thing that you got to do is you have to get some type of petition going, some type of motion. You got to get back in court. Either do that through filing a modification, or you can send in a termination affidavit with demand for dismissal. Your state is incentivized by the Title 4D program to establish a child support case against you. This will basically mean that the decision that's made for you to be put on child support is made by a biased individual, someone who's not neutral. So the second thing that you have to do is you have to include into your argument and into your paperwork that your right to due process has been violated because the decision is made by a non-neutral party. And remember, we don't want to support these kids no more. So the next thing that you actually have to do is go file for legal custody. That's right. You want to go get 50-50 legal custody. That means you'll have your child 50% of the time, and then you will not be considered a non-custodial parent, because only non-custodial parents have to support their children. And the fourth way to make sure that you're not supporting these children is to stop the wage garnishments, okay? They're not supposed to be taking your money. If your money is being garnished by child support, you can file a motion to have it stopped, because that also violates your right to due process. And the fifth way that you can make sure that you're not supporting your children is to go ahead and sue your child's mother if she's on welfare. Because she's on welfare, you're the only one that's making the payments. She's not doing anything because she's receiving the money from the government. And both parents are supposed to take care of the kid, right? File a lawsuit against her for not doing her part as a parent, and this will assure that you do not have to support your children anymore. When I say not support your child, I mean through the system. If you become a custodial parent, you can take care of your children on your own. You don't need anybody to dictate how you're supposed to take care of your kids. We got to get this word support our children out of our context and our way of speaking. We got to do what we need to do for our children and make sure that we step up and be real fathers. Make sure, most importantly, the best way to be and do all those things is to have your child in your life consistently. And if you're dealing with parental alienation, you need to step up. So yes, I am teaching you how to not support your children. I'm teaching you how to step up, be a man, and take care of your kids without the involvement of a government entity.
So this is why it's very important that you do your own research and not listen to everything that you may hear just because it sounds good. It's also important that you actually retain counsel or consultation for someone that understands the system. So with respect to this video, there are a few things that I do like about it or not. First thing, I agree with him 100% that you should step up and be a father and take care of your children. And it is not a good idea to have the system, the government, or the courts involved in your life to make decisions for you. I am 1,000% in agreement with that. But the problem with that is that unfortunately, a lot of families cannot agree to actually allow that to happen. Now, with respect to the remaining portions of the video, it's confusing, and it sounds to me that it mixes a bunch of stuff in that's not applicable, and it can be confusing and not beneficial. First of all, the first thing he said is that it's easy to terminate your child support case. And in my practice, and where I have practiced, and I practice primarily in Georgia, I've had cases in other states. I have domesticated orders from other states into Georgia. I've actually handled cases in California and I think Idaho. And I will just tell you, in my nearly 20 years of practicing law, it is not easy to actually terminate a child support case. Can it be done? Absolutely. But you alone cannot do that. Now, one way that you can terminate a child support case is For instance, let's say you and mom come up with an agreement and you filed a motion or a consolidated motion, say, hey, we have agreed that child support is unnecessary at this point. The court may consider that and grant it. Now, I would say that this is the case in the jurisdiction that I practice in. Other states may be different, and because I'm not licensed in those jurisdictions, I can't say that. But in my practice and in my jurisdiction, I don't know of any a lot of ways that it can be terminated. Another way child support can possibly be terminated is, let's say, when child support was initially established, mom and dad were not married, but subsequently they got married. Both parents live in a home, the child lived in the home with them. And then again, they filed a consent agreement to terminate the child support order. And even with that, the court will have to do what's called an evidentiary hearing to determine if it's in the child's best interest to terminate the order. Oftentimes, if it is a consent agreement, the court will likely grant it, but it's not guaranteed. Because at the end of the day, it is not about mom, it's not about dad, it's about what the child is entitled to and what the child needs. And the court, unfortunately, when parents can't get along, have to step in and make that decision. Okay? He also says that you want to challenge due process and you want to challenge jurisdiction. This reminds me of people who like to holler and shout about their rights have been violated. Oftentimes, people do not know what their rights are. I give you an example. A lot of times, when the police approach you and ask your name, can I check your car? Let me do a strip search. Can I enter your home? Many people will allow the police officer to do that, not realizing that they have an absolute right to not allow the police to do that. Most people know the word or the term probable cause, but most people don't understand what that means. Okay. So, with that being said, you can holler and talk about what kind of rights you may have, but if you don't understand what they are and how to apply them, it means absolutely nothing. So, when he says that you can argue that your due process rights have not been violated, you need to know what he's referring to. Oftentimes, when you have a petition for child support and or custody, the due process issue is dealing with notice. So, for instance, let's just say you mom filed a lawsuit against you for child support, or the child support office may file a lawsuit on behalf of the child for child support, and they go to a hearing, but you didn't get notice of it. Well, that is a due process violation. But guess what? That's not usually the case. Most oftentimes, you actually will get notice. They will find out where you are. You are getting noticed by either a process will serve you, or most time, I wouldn't say most time, but sometimes you'll get a notice like on your door. Even people have gotten emails and they'll go down to the sheriff's and the marshal's office and they will actually pick up the document, which is something that I don't necessarily recommend, because guess what? The law and due process, as he made reference to, allows you are entitled to personal service. So allow the law to work to your advantage, because that is the law. But challenging due process, particularly when it comes to the issue of service, that's not guaranteed, because this is generally not an issue. Then he says challenge jurisdiction. Well, again, it goes right back down to what are your rights. Do you even know what the word jurisdiction means? Most people do not. Well, jurisdiction simply means, is it the court or the state, the proper place for the case to be brought? An example, let's just say you live in the state of Georgia and the child lives in New York, and mom lives in New York, and you just moved from New York and you're now in the state of Georgia. Mom filed a lawsuit in the state of New York. Perhaps the argument will be that dad no longer lives in New York, so that state does not have jurisdiction over him. That is not always the case. Sometimes jurisdiction is not an argument to be made. So, to make a blanket statement that jurisdiction is a way to argue against or challenge it so that your case can get thrown out, this is just hogwash, because it's not applicable in most cases. Sometimes it is. And a lot of time, even if it is a valid argument, that doesn't mean that's the end of your case. I'll give you another example. Let's just say both parents live in the same state. And again, I'll use Georgia, since Georgia is the state that I practice in. Both parents live in the state, and dad lives in one county, the children lives in another county with mom. Mom filed a lawsuit in the county that she lives in, and dad in Georgia is entitled to be sued in the county of his residence. And I'll give you a few counties, very popular counties. Fulton County, which is where Atlanta sits, is very popular. Let's just say mom lives in Fulton County with the children, and dad lives in Monroe County. Well, guess what? Mom needs to file the lawsuit in Monroe County, but mom decided to file the lawsuit in Fulton County. Now, that's not a jurisdiction issue. That's more of a venue issue. And dad could argue that this is the improper venue. And again, you need to know what these terms mean. You need to know whether or not this jurisdiction, or you need to know if this is a venue. But even in the case where it's a venue issue, that's not going to throw your case out. What a judge could do, or an attorney, is just move the case from Fulton County to Monroe County, because that's the proper venue. The jurisdiction in that particular case is whether it's going to be state court or if it's going to be superior court. So again, it's just not this simple. And these particular defenses that he make reference to are not guaranteed, and oftentimes, if they are valid arguments, they're not likely to throw your case out. Okay? Now, he made reference to a tool, FCA, something he created. I don't know what that is, so I can't speak about it. But then he also goes on, he said there are 5 ways that he can guarantee that you do not have to support your kids forever. Now, I think that this is not as harsh as it sounds, because he does not say you shouldn't take care of your children. He just simply say we're not going to have to. He doesn't want you to have to take care of your children through the system. And I agree. As an attorney that actually deal with child support, I draft child support calculations. I support it. I do all of that. I agree that it is better for the parents to work it out if they can. And if they cannot, then that's where the courts come in to play. So one of the things he says that the United States Supreme Court has says that child support does not benefit the child. Again, I have zero understanding of what he's talking about, but I did do some research to find out, because this is not the first person to say that. So I did read some research, and I looked at AI overview. And of course, what I suspected, the U.S. Supreme Court did not say this, but supposedly the United States Supreme Court did say that it does not create an individual entitlement to services for children or their custodial parent. The court clarified that substantial compliance requirement and child support enforcement was a yardstick for measuring the state's performance statewide, not a guarantee of individual rights or services for families. This does not discuss in any way, shape, or form whether or not child support benefits the child or the parent. And quite frankly, child support does benefit the child. Let's just take a scenario. Let's just say you and mom are living in a happy, harmonious relationship in the same house with the child. Child has to eat. The child needs a place to stay. The child has medical expenses because they got to go to the doctor. They might have to get the shots. They might have a bloody nose. The child has sports. The child needs clothes. All of those things require money. Okay? Even the roof over his head and the light and the electricity and the water the child used to take a bath, that requires money. If you and mom no longer live together, guess what? That child still needs that, which means in order for the child to still have those services, the ability to eat, clothes, shelter, lights, activities, money for medicine and medical visits and stuff, eyeglasses, sports and stuff, that still is money. That child still is entitled to those services from both parents. And for that reason, child support does benefit the child. Now, can child support be abused? I believe so, because we've seen it a lot. Sometimes child support is paid to the custodial parent, and unfortunately, oftentimes the custodial parent is the mom. And we have seen situations where the mom has abused it and used it for her benefit. I do not believe that is the norm. I think that is not the norm, but that's not an issue for debate. But in any event, in my opinion and in my experience, child support does benefit the family, and it definitely does benefit the child. The second thing he said, with respect to the Supreme Court statement, you need to file a petition or a motion. Now, to me, this makes no sense, because in one breath you're saying you want to get rid of the government in your business, but in the second breath you're saying file a petition or a motion in court. Now you're getting, maybe not necessarily the government, but you're getting the courts back involved in your business. And the fact that he is saying government and then courts and interchanging the two, they're just not the same. I can kind of see how they can be a bit conflated, but not really. And that's the other thing. When it comes to law, we don't do a lot of interchanging and using the same words. That's why it's important to understand what are the right terms are, because you may say one thing and it means one thing in layman's term, but it means a completely different thing when it comes to the law. So let's examine what he said. He said file a petition or a motion in court. What are the difference? Big, big, big difference. First of all, a petition is what you file to start a lawsuit. A motion is filed when you already have a petition already in existence. So, for instance, when you file for child support, it's the first time you're filing for child support, or you're seeking a modification. That is generally a petition. You're starting something new, and perhaps something happened years ago and you have to start over again. That's a petition. A motion is you're asking the court to do something while you are already in court. So let's say, for instance, you filed a child support petition to establish child support, and now maybe 6 or 7 months down the line, you lost your job. You file a motion to modify. A motion temporarily to modify because, Your Honor, I no longer have a job because my job went out of business and I'm looking for work. That is a motion. Now he says, file a motion or a termination affidavit with a demand for dismissal. Again, be very careful when you hear folks talk like this that have very little to no experience except perhaps their own when it comes to the law. Again, I'm a lawyer. I do this work and have done this work for many years. I can't tell you that I know everything when it comes to the law. I can tell you that I've been very successful, and my experience is limited to my jurisdiction where I practice. So perhaps the work that I've done here may not be applicable to other states, but I personally think that it could be. But just because I did something with one person and been successful, or 1,200 people, that does not mean I'm going to be successful with you, because each case is different. But let's examine this. You file a motion to modify. Well, what that means is that you have a child support order already in place. Presumably, he's talking about a child support case, and you're asking to modify. Well, I know in my jurisdiction, you just can't simply modify because you want it to be modified. There have to be circumstances to warrant a modification, right? And this is something he left out, because you can't simply say, I'm going to file a modification. In Georgia, you have to be able to establish, one, there's been a change in circumstances to do so, right? And you can't just willy-nilly file child support just because, oh, today I feel like I need to get it done. No, sir, that's not how it works. Then he says, you can file a termination affidavit with a demand to dismiss. Good luck on that. That's all I'm going to tell you. Now, in my jurisdiction, I don't know anything about that. An affidavit is good, but oftentimes an affidavit is attached to either a motion or a petition. But an affidavit to terminate, again, good luck on that. And most courts, and I don't know other courts, but I will say just about every single court in the United States, they operate on motions, not affidavits. Affidavits are supporting documentation that supports your motion. So filing an affidavit to terminate, yeah, I don't know about that, but good luck on that. Okay. Now, again, even if you were to file a motion to terminate child support, that presumes that there is a case already established. Now, can you file a petition to terminate child support? Absolutely. But you need to understand, how do you do that and when are those circumstances? Let's examine both. Let's say you file a motion to terminate child support. Let's just say your child is still a minor. Your child is 10, 11, 12, 13, 14 years old, and you're paying child support, and you have an open case, right? And you file a motion to terminate. What grounds are you going to do that? Because I want 50-50? Good luck on that as well. Oh, because I don't want the government in my business, good luck on that as well. That is not going to fly in almost every jurisdiction. But I can tell you for definitely not in the state of Georgia. That's not going to happen. Can it be circumstances where the court will do that? Absolutely. But it's based on that circumstances. Now, let's just say you have a petition to terminate child support. That's different because remember, a petition is a new lawsuit. And in this particular situation, let's just say you had a child support order that was established 18, 19, 20 years ago. And your child is now an adult and your child support order has ended. Well, mom is still collecting child support because it's been taken out of your child out of your check every month, or child support services is garnishing your wages. And you've called child support and you told them, listen, I don't need to be paying child support anymore. The child has aged out, and they're ignoring it. Well, at this point, you can and should be able to file a petition to terminate because the child support order has been fulfilled. Those are circumstances where you can do that. Simply willy-nilly telling someone that you can file a child support petition to terminate or a motion to terminate, again, good luck on that. That's not likely to work. Okay. Now, he also mentions that the state is incentivized to establish a child support case under the Title IV program. He said you mentioned this in your argument that because your argument to terminate child support because it's being made by a non-neutral person. The decision to put you on child support is based on a biased individual. And the Title IV program does this, and you can use this as an argument. Well, again, do your homework because this is just not accurate. So, again, I did some research on Title IV. I just want to know for sure. I know, but I'm a lawyer, and part of being a lawyer is researching and understanding. And sometimes we can research and another attorney can research and have two different interpretations. And the judge can come in and research as well. And guess what? We may all have three different interpretations of what it is. But I would tell you what this young man said is just not accurate. So I did some research, as I said, and just an overview. This is an AI overview of what Title IV is. Title IV D refers to federal law that mandates states to operate a public child support enforcement program. This program, which is funded by federal money, provides to states help ensure the child receive financial and medical support that are owed by the non-custodial parents. The key function of this program includes locating the parents, establishing paternity, setting up and enforcing child support orders, and distributing payments. The program also helps to provide services to non-custodial parents and pro se litigants. And like, for instance, if you're representing yourself and you need an attorney or there's some literature or something like that, those are funds sometimes that are available through the state or through the government that are offered through the state to help non-custodial parents and pro se litigants. Now, and a prime example, I deal with this all the time. So in my practice, I prefer to go straight to court and file it and not go through child support. But let's just say your child and your child's mother, well, the mom has gotten food stamps or Medicaid through the state, and those programs are federal. Well, because the child is entitled to benefits or entitled to financial support from both parents, the state and the government are working in tandem to be able to locate the non-custodial parents to pay back what the state and the federal government is paying for this child. So, for instance, if mom is getting $300 a month for food stamp to feed little Johnny, and another $200 a month for Medicaid, that's $500. Those money should be coming from both parents, the parent that's a custodial parent and the parent that's a non-custodial parent. And because both parents are required to take care of the child and the non-custodian parent is not paying for that, that is one of the reasons why they're trying to locate the non-custodial parent to pay those monies back, because that is the parent's responsibility, not the state and not the federal government. That's how that actually works, not the other way around, not the way that this was mentioned in the video. Now, The other thing about this is, as I said before, the program also help people that don't understand the process. Like if you were to go to some course, particularly in family law, they have a lot of literature there. They may have some videos that you watch. Supposedly, Title IV provide funding for those type of videos, for that type of literature. Sometimes they might even have law day or legal day where they have attorneys that volunteer and give non-custodial and pro se litigants legal advice for a period of time. Those were those funds are used for. Okay. He also says include in your argument that your right to due process has been violated because the decision to put you on child support was made by a non-neutral party. So, again, what he is generally talking about is if the state filed a child support case against you. And again, when the state has filed a child support case, it's oftentimes when the custodial parent has gone to the state and gotten benefits, food stamp, Medicaid, um, maybe Section 8 or something like that. The state is paying for the care of your child. And when that happens, the state is filing on behalf of the child. And so he is saying that you can make an argument that the person that filed the petition is biased. Again, you can make that argument, but good luck on that, because quite frankly, they are. If nobody is not biased, just completely neutral, it would be these folks. Their only goal is to recoup money that they are paying for your child, and you can call that bias or not. But either way, that argument is not going to fly. Now, if it flies for some folks, good luck, and that's a good thing. But I don't see it. And I, quite frankly, I don't even think that's a good or plausible argument, because at the end of the day, the laws clearly says that you have a responsibility to provide for your child. And the fact that someone filed a lawsuit against you or on behalf of the child and they're biased, well, guess what? Everybody that filed a lawsuit is biased. Every person on the left of the V and every person on the right of the V, they are biased because they believe their side. So if everybody that is biased in a lawsuit can be thrown out simply because they're biased, there would be no cases. So that's not a good argument at all. But in the other thing, he says that the party that filed the lawsuit is actually not neutral. First thing, if he's again talking about the state, which is Department in Georgia's Department of Family and Children Services, or its equivalent in other states, maybe like the Child Support Office, if they are filing on behalf of the child, they are not really considered a party. They are actually filing on behalf of the child, and they cannot be brought to court usually to testify about what the child needs or anything like that. They're simply there to establish a child support order. At least that's how it works in Georgia. Anyway, then he goes on to say you can file a petition for custody and seek 50-50. And then, well, that's the first. So let me address that. You can file for legal custody and seek 50-50 custody. Again, in one breath, he says that you don't want the government or the courts in your business, but then in the next breath, you're going to get the government in your business to get 50-50 custody. They're quite the opposite. I mean, they just are. They're the opposite. You can either choose to let them be in your business or you're not. But let's take it from the position he says. You're going to be in my business. I'm going to file a petition for custody 50-50. Well, you have to be able to establish whether or not it is in a child's best interest that 50-50 is going to work, because it may not be in the child's best interest. And I will tell you, I believe in 50-50 custodial arrangement. I am 100%. But I just had a case recently in Georgia where the parents were married and they agreed at the onset of their divorce that they will have 50-50. Mom will have 50-50, dad will have 50-50, and they agreed that there will be no child support, right? Well, maybe, I don't know, a couple months later, one of the parents wanted to file a modification because they believe one parent was ostracizing the child from the dad, okay? So what happened, we get to court and the judge says he does not agree with 50-50. But he didn't modify, he didn't change anything because there was no grounds for it. So there are instances where judges do not believe that it's in the child's best interest that 50-50 will work. Now, of course, you can challenge that by appealing it, but sometimes there may not be grounds for appeal. And particularly if you don't know how to perfect the record such that when you go on appeal, you could win, then you're back at square one. So, this is why to make such a statement, particularly such a blanket statement, is so damaging and harmful. And it's reckless because there are some folks that will honestly believe this. But let's take another approach. Let's just say you have a child support order in place, right? You're challenging that child support order because you don't think the government to be in your business. Then you go and file for custody. First of all, it's not smart to have a child support order on one track and then you have a custody case on another track. That just doesn't make any sense. When folks come to my office and they're either trying to establish child support, legitimation, and custody, we do it all at once. It saves you time, it saves you money, and it saves you resources. Now, aside from that, if you're going to go and do that, and you're talking about you don't want to pay child support, why would the court grant you 50-50 when you don't want to do the bare minimum of taking care of your child? Just think about it for a minute. It does not matter what your emotional or your beliefs say to you. The court operates on what the law says. Now, will the court give you credence and give you lead or give you discretion or give you deference because you are a good parent, you're a good father, you're involved? 100%. But the fact that you think that they shouldn't be in your business and you say this to the court, good luck on that. It's actually considered disrespectful because guess what? The court didn't file this petition. And even if the mom filed the petition, unless you can establish that she did this and it's not warranted, again, good luck. But let's go further. Let's just say you have this child support order in place. You may or may not be trying to get it dismissed. But if you are not paying child support according to the order, and you're now trying to establish custody and 50-50, courts are not dumb. Judges have been around for a while and they understand that a lot of times non-custodial parents seek to have more custodial time with the child because they don't want to pay child support. And so, again, good luck on that. Now, one way to try to establish 50-50 custody, you try to do that from the onset. And you need to establish it at the beginning, way before the order has been created. You can even do that simply by keeping a track of evidence of what you have been trying to do to be with your children. Okay? And there are ways to do that. I have been very successful at getting my clients, and my clients, as you know, are men. I represent fathers. Almost 99% of my clients are dads. But there are ways that you have to be able to do things so that you can get 50-50. The court needs to see that it's in the child's best interest. But if you have no history, you cannot establish why it's in this child's best interest that you are entitled to 50-50. Good luck. Because what I see when I hear this, men are taking from the position that it's me, 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 me. And quite frankly, my dear, it is not about you. It's all about the child. So take it or leave it. But I'm telling you, I got nearly 20 years of experience and I know what I'm talking about. Now, the next thing he says, you want to, he says that you want to do 50-50 so you won't have to pay child support. Again, courts know this. They are aware of this. This is a tactic. And so do moms. Moms know this as well, and so do attorneys. So don't hang your hat on this unless you can establish that it's in the child's best interest, that 50-50 will work. Again, good luck. But he also says only non-custodial parents pay child support. And he says by establishing 50-50, there is no, they're both the custodial parents. This is not true either, because if there's a child support order in place, there has to be a child support, there has to be a custodial and a non-custodial, even if it's a very short, in terms of percentage, maybe 42% and the other one's 52%, 48, 52. One is going to likely have more time with the child than the other. And that's just, in the jurisdiction that I practice. While it is common that the non-custodial parent pays child support to the custodial parent, it can also be the other way around. I have seen it. The law does not specifically say that the non-custodial parent must pay child support to the custodial parent. That's not the law. I have had cases, I have seen cases where the custodial parent was paying child support to the custodial parents. And there's case law that actually say this. So don't, again, hang your hat on the fact that the non-custodial parent is the only one that pays child support. Oftentimes, that is the case, however. Okay? Now, he goes on to say you need to stop the wage garnishment. They're not supposed to be garnishing your money because this also violates due process. My God. Again, I don't know anything about that. I understand how you don't want it to be garnished, but one way to avoid that is to go and file child support yourself and the proper court, right? Because in the proper court, you and mom can agree whether or not it needs to be garnished. In Georgia, we have something that's called an income deduction order, where it actually is pulled out of your paycheck every single month. But if you file suit in here in Georgia will be the Superior Court, and you and mom agree that it doesn't have to be garnished out of your wages, I trust that you're going to pay, then guess what? It doesn't have to be garnished. So again, this is why it's important to not only know your law, know the law, but also know your rights and know the jurisdiction that you're in and how it works. Because just listen to folks just say this stuff, it can be very, very dangerous and not helpful at all. Then he also says the next thing, you need to sue your child's mother if she's on welfare, because you are the only person making payments, because she is receiving money from the government and both parents are supposed to take care of the child. Again, good luck. I don't know anything about that. And oftentimes, when a parent is on government assistance, it's because they need it. And you're trying to sue the mom because she's on support and she needs to take care of the child. The the first thing is like, what are you suing her for? What are the causes of actions? Are you suing her because she's on support? If that is the case, then the question to be asked, do you have standing to file a suit against her? You probably don't. The question then asks, do you know what standing is? Now the next question, are you filing suit against her because she is on on social services and she shouldn't be on there? Well, again, question is, do you have standing? And maybe she committed some crime or fraud to say that she's on it. Again, the question is, do you have standing? Are you filing lawsuit against mom because she should be working and being taking care of the child? Well, perhaps you may have standing in that situation, but then the case is this a viable case? Can it stand the test of time? Is this a real cause of action? Without knowing more, I will say absolutely 100% unequivocally no. It's not viable. Because guess what? If mom is on support, food stamps, housing, welfare, whatever it is, oftentimes the people that are on there, they meet some qualification of some kind of income qualification and they qualify for these benefits. Now we have heard people have been on these programs and have abused it and have lied about it. That's common. But aside from that, a lot of times these folks that are on these programs, they qualify for it. So you don't even have a right to file suit against them if they're on it. Now, the idea that you're going to file suit against mom because she's on it, because she's not paying child support and she's not working and she doesn't have an income and therefore she can't pay child support and now it's all on you. The thing is that there are a lot of parents that are working and they're still getting benefits because they just can't make ends meet with their income. There are people that are making decent money but don't have health insurance, because their money don't, their income is just not enough. And so they have to get Medicaid, or they may have to get some kind of subsidy for housing. So again, to make blanket statements like this is kind of reckless in my opinion. But anyway, this is my thoughts. Let me know what you think. I'm sure there are many that may disagree. Let's talk it out. leave me your comments in below. I will look at them all. I will try to respond to them all. And until next time, this is Attorney Ella Hughes, the Bulldog attorney fighting for justice and the father's advocate. And I'll leave you as I always do. Don't stop fighting. Your children do need you.